Yes.
So, Michael, just still on the topic of blood products and licensing of blood products and hepatitis, a general question, if I may. Would you expect that when the CSM or the licensing authority were considering whether to grant a product license in the UK, that they would look to see how that product had performed in the US and any safety issues arising from its use in the United States?
I would hope so, yes.
Secondly, could the licensing authority or the CSM have made it a condition that concentrates should not be supplied if they were made from plasma taken from prisoners?
I suppose I'm disappointed. But of course, as you know, I wasn't around at that time.
No, quite. But in principle, if it was known that plasma was being collected by the pharmaceutical companies in the States from prisoners or other high-risk groups, could the CSM, in theory at least, have imposed a condition excluding such sources of plasma?
Well, it could have done, yes.
And then more generally, and again, conscious that you weren't around in the 70s, but drawing on your knowledge of the CSM more generally, are you able to offer any insight into how it was that these products made from large plasma pools were licensed, notwithstanding the fact that it was known that they transmitted hepatitis, which could have serious, indeed fatal consequences?
Well, did people know that?
I can't really answer that for you, I'm afraid, Sir Michael.
Sorry. I don't know when...
The evidence that we've had, Professor, is that it was declared on the licensing application by the pharmaceutical companies themselves. So I think the conclusion has to be that the committee must have known something of that, or at least sufficient to investigate further had they wished to do so. But that's the evidence that we've had.
Are you able to do you have any reflections on that as drawing on your knowledge of the committee's decision making?
No, I don't know. No.
Can I then turn to a meeting of the Committee on the Safety of Medicines in July 1983? And this was looking at the risk from AIDS and factor concentrates. So I'm just going to take you to a couple of documents, Sir Michael, just so that we can see what material existed. If we start with ARCH 0001710, you'll see, Sir Michael, this was a decision of the Biological Subcommittee on the 13th of July 1983. If we go over to the second page, you'll see near the top the heading Acquired Immune Deficiency Syndrome. It says the subcommittee's consideration of the question of AIDS and licensed blood products was augmented by the following expert advisors, and then 5 individuals are identified: Professor Bloom, Dr. Krask, Dr. Galbraith, Dr. Gunson, and Dr. Mortimer. And then a series of conclusions are set out. Now, I'm not going to take you through those conclusions, Sir Michael. I just want you to see the document. That's the Biological Subcommittee meeting on the 13th of July. And the Biological Subcommittee was deciding what, if any, action should be taken in relation to the continued importation and use of factor concentrates given the risk of AIDS. Now, that came before you and your colleagues later in July of 1983. And we can see that at DHSC 0006259_007. So if we just go to the top of the page, please. Committee on Safety of Medicines, minutes of the meeting held on the 21st of July 1983 and 22nd of July 1983, and you were one of those present, Sir Michael. If we go over the page and we look at the bottom, the bit that's been highlighted in yellow on the screen, tabled paper 4, summary of main points from a consideration of AIDS and licensed blood products by Biological Subcommittee, 13th of July 1983. That's the set of minutes I showed you a moment ago. 5.1, Dr. Smith spoke to this paper and reported to the committee on the above discussion. 5.2, the committee endorsed the recommendations of the Biological Subcommittee. Now, first of all, Sir Michael, do you have any recollection of this meeting or of the CSM's consideration of this issue?
No, I don't. Not at that time, no.
It would appear from what's set out here and from other documents that I don't need to trouble you with, that the only material before the CSM itself was Dr. Smith's paper, and that the CSM didn't have any underlying materials that the Biological Subcommittee may have seen. Does that surprise you, or was that normal?
That would have been reasonably normal, I think. I mean, the experts on this subject were in the Biological Subcommittee. And there were very few members of the CSM itself who had any expertise in this area.
So we obviously can't really, from the minutes and what you see on the screen, really glean anything about the committee's decision-making process. The fact that it said that it endorsed the recommendations of the Biological Subcommittee, might this be an example of the CSM essentially simply rubber stamping what the Biological Subcommittee had resolved?
It could well be interpreted in that way, yes.
And then if we just go to the paper that Dr. Smith produced, it's on the next page, please, of this document, please, Paul. We can see there, if we just look at the top of the page, so this is Dr. Smith's paper, tabled paper 4, summary of main points from a consideration of AIDS and licensed blood products by CSMB, 13th of July 1983. Now you'll see the first paragraph explains that the subcommittee had been helped by the various expert advisors whose names I showed you a minute ago. Neither the Biological Subcommittee's neither the minutes of the meeting of the Biological Subcommittee nor this paper from Dr. Smith sets out what the advice of those experts was, what their contributions to the meeting or to the discussion were. Does that surprise you that we can't tell from these documents what the experts were advising?
No, I don't think so. I think it was sort of summarising the views of the subcommittee.
And then if we just look a little further down the page, please. So first of all, to the paragraph number 2. So this is the reasoning of the Biological Subcommittee, which you and your colleagues on the committee were endorsing. Paragraph 2 says this: patients who repeatedly receive blood clotting factor concentrates appear to be at risk, but the evidence so far available suggests that this risk is small. the risk appears to be greatest in the case of products derived from the blood of homosexuals and IV drug abusers resident in areas of high incidence, e.g. New York and California, and in those who repeatedly receive concentrates in high dosage. Balanced against the risks of AIDS and of other infections transmitted by blood products are the benefits of their use. In the case of haemophilia, they are life-saving. Now, I wanted to ask you about two statements in that sentence and in that paragraph, Sir Michael. First of all, the suggestion in the first sentence that the evidence so far available suggests that this risk is small. I appreciate you can't remember this meeting and you don't know what evidence was considered, but would you have expected the biological subcommittee to have gathered as much evidence as it could, but as was available by July 1983, about the extent of the risk?
Yes, I mean, I don't know what, because it is really a sort of summary,
Yes.
isn't it? And it appears to be greatest in the case of products derived from the blood of homosexuals and IV drug users. And I just wondered if they'd got any numbers associated with that, but I don't know.
The biological subcommittee appears to have been of the view, this is the end of that second paragraph, that blood clotting factor concentrates were life-saving for haemophiliacs. And you yourself in your statement, Sir Michael, used that term on more than one occasion, that they were life-saving. Do you know what the basis was for believing that factor concentrates were life-saving for haemophiliacs? Would you simply have taken that as read, do you think, on the CSM?
Well, I think we understood that haemophilia was, until these products became available, was indeed life-threatening. People with haemophilia had catastrophic hemorrhages, and all that could be before these concentrates became available. All that could be done was to give them blood and fresh plasma in the hope that they would take effect. So I don't think that. So I mean, it was and of course also in haemophilia, quite apart from the catastrophic hemorrhages that haemophilia got or used to get, they have also chronic bleeds into joints and, giving them chronic arthritis and so on. So
that wouldn't be life-saving, however, would it?
No, but catastrophic hemorrhage would be.
Yes. Would you have expected the biological subcommittee to rigorously examine and interrogate the evidence about the advantages of factor concentrates when reaching its recommendations?
Yes, I do. And we haven't mentioned it yet, but one of the medical staff of the Medicines Control Agency, or the Medicines Division, was a woman called Frances Rockblatt, who, before she joined the Medicines Division, had done a lot of research on haemophilia and concentrates. She was a great woman, and she died not long ago.
Yes.
About 6 months ago. She had an obituary in the Times.
Indeed, there's no evidence, I should say, Sir Michael, that Dr. Rockblatt contributed anything in writing or orally to the material before the biological subcommittee.
Well, we took great notice of what she had to say about biologicals.
If we just go over the page, this is paragraph numbered 4, so it's the paragraph at the top of the page. And I just want to ask you about the, well, actually, no, I'll read the whole paragraph and then ask you. The possibility was considered of withdrawing US preparations from the UK. It was concluded this was not at present feasible on grounds of supply. Moreover, the perceived level of risk does not at present justify serious consideration of such a solution. Efforts are, however, being made to secure UK independence of foreign suppliers of clotting factor concentrates. This should reduce markedly, although not eliminate, the risks to recipients of these products, and the subcommittee strongly supports this aim. Now, just pausing there, you'll see it's being said there that the perceived level of risk did not at present justify serious consideration of withdrawing US preparations, and that wasn't at present feasible on grounds of supply. So it appears to be contemplating a situation that might change, or indeed the balance of risk might change. Would you have expected the Biological Subcommittee and indeed the CSM to keep this issue under review and to actively look at it again after July 1983?
Well, I would hope so, yes.
There is, I think, at present no evidence to suggest that the Biological Subcommittee or the CSM did so. Does that surprise you?
Yes, I thought at least the Biological Subcommittee would have done.
And then the last sentence of this paragraph reads, the subcommittee was also informed that the UK Haemophilia Centre directors have adopted a policy for use of US Factor VIII in order to minimise risks as far as possible. Now, there's no evidence that the actual policy adopted by the Haemophilia Centre directors was before the subcommittee, but would you have expected the Biological Subcommittee again to rigorously examine what the policy was and whether it struck the balance in the right way?
Well, I'm not sure. I mean, the centre directors knew what they were sort of talking about, and so I suppose that's the subcommittee assumed that they did.
Could we look at one further document, CBLA 000043_040? Now, Sir Michael, there's no suggestion that this is a document that you saw or that your colleagues saw at the time in July 1983. You'll see it's a letter from Dr. Galbraith of the Communicable Disease Surveillance Centre to a Dr. Field at the Department of Health and Social Security. It's dated the 9th of May, so it's a couple of months before the Biological Subcommittee meeting and then the Committee on the Safety of Medicines meeting. If we look at the text of the letter, the first paragraph refers to reported cases of AIDS in haemophiliacs. And then the second paragraph says, I've reviewed the literature and come to the conclusion that all blood products made from blood donated in the USA after 1978 should be withdrawn from use until the risk of AIDS transmission by these products has been clarified. Appended is a paper in which I set out my reasons for making this proposal. And if we go over the page, this is the paper referred to in the letter, and it sets out 6 points. Point 1 is that the AIDS epidemic in the States is probably due to a transmissible agent. Point 2, the agent is probably transmitted by blood and blood products, and details of reported cases are given. Point 3, if we could just zoom in on paragraph 3, Paul, says, although this number of cases of AIDS associated with the administration of factor VIII concentrate is very small in relation to the number of individuals receiving the product, this may not indicate that the risk is small, and he goes on to explain why. The next page, please, Paul. We can zoom in on paragraphs 4, 5, and 6. Paragraph 4 says that factor VIII concentrates would appear to have a high risk of being contaminated with AIDS because homosexuals and drug abusers are known to be frequent blood donors. Paragraph 5 makes the point that there's no means of ensuring that blood or blood products are free of AIDS, and paragraph 6 refers to the extremely high mortality rate of AIDS. Now, given that this was a document which the Department of Health itself had, do you consider this is the kind of material that the biological subcommittee and indeed the committee itself should have been provided with?
Yes, I think at the very least the biological subcommittee should have been provided with it.
And looking at it now, do you think, doing the best you can, if you and your colleagues had this document with the reasoning there spelt out, do you think you might have reached a different decision?
Yes, I mean, I hope so, but I wouldn't guarantee it because, as we've already discussed, you know, haemophilia is a life-threatening condition. So I don't know.
And then just finally on this topic, can I ask you to look at one passage in your witness statement? It's at WYTN 6406001. If we go to page 64, and it's paragraph 16.21. And so, Michael, you're talking here about the meeting that we've just been considering. You say, although I cannot recall the factors that led to the conclusion that it was not feasible to withdraw factor concentrates and replace them with cryoprecipitates, I think that decisions such as this would depend on the nature of the risk and its frequency, as well as the nature of its benefits. And then you go on to talk about that and what you understood to be the risk to haemophilia sufferers. And then you say at the very bottom of the page, it's not possible to say what would have, and if we go to the top of the next page, been considered to be the necessary perceived level of risk for factor concentrates to be withdrawn from the market. But I think it is correct to say that if we had known then what we now know about AIDS, urgent action would have been taken, and it is possible that those products would have been immediately withdrawn. What kind of information did you have in mind, Sir Michael, when you say if we'd known then what we now know about AIDS?
Well, I think if we'd known then what we know about AIDS, that it's caused by a virus, because at that point it was suspected it was an infectious agent. If we'd known it was caused by a virus, and if we'd known how frequently pooled donors in the US had the virus, then I think we would have done something different. At least I hope we would have done.
I'm going to move now to ask you just a handful of questions about heat-treated factor concentrates.
Yes.
So I think we only need to look at one document to start with. It's DHSC 0003947_015. If we just look at the top of the page, please, Paul, to see the date. So this is the CSM meeting on the 22nd of November 1984. And again, you were present. If we go to the last page, please, Paul. Paragraph 17, any other business aids. Dr. J. Smith informed the committee that heat treatment of factor VIII, which is used in the treatment of haemophiliacs, abolished detectable infectivity of AIDS virus added to the preparation. Therefore, companies should be encouraged to apply for variations of licenses to permit widespread use of heat-treated factor VIII so that the incidence of AIDS in haemophiliacs might be reduced. Professor Rawlins reminded the committee that heat-treated factor 8 is more expensive than the standard preparation. Widespread substitution of the heat-treated product may cause haemophilia centres to exceed their budgets. The committee requested that the licensing authority propose to the companies concerned that they make early applications for variations to use a dry heat treating process in the manufacture of their factor 8 products. So Michael, first of all, what was the relevance of your observation about the expense of heat treated factor 8?
Well, I don't know, and I'm sort of surprised I said that, really, because a little bit late, not long afterwards, I was recommending that all patients who with haemophilia were given heat treated, and that we should, as it were, ignore the expense or accept the expense. So I'm not quite sure why I said that then.
And then, if I can just draw your attention to a paragraph of your statement and ask you about that. So, Paul, can we have up on screen WITN 6406001, and it's page 79 of your statement, Sir Michael, paragraph 17.6. So in paragraph 17.6, you were commenting on the passage we've just looked at, and you say this: it's difficult to recall the CSM's exact intentions now, but I think that the reason the CSM recommended encouraging companies to apply for variations rather than making heat treatment a mandatory requirement was because there would have been a concern about such a mandate leading to a shortage of factor 8 products. As the inquiry knows, these products were life-saving and life-changing, and the implications of their becoming suddenly unavailable would have been very serious. While when judged with the benefit of hindsight, this may seem to have been the wrong approach, in late 1984, the full implications of the AIDS virus were still not widely understood. But first of all, Sir Michael, would it have been possible for the CSM to recommend making heat treatment a mandatory requirement? It
would have been, yes.
Yeah.
It would have been, yes.
Was any consideration given, do you know, to the issuing of a Dear Doctor letter to try and ensure that clinicians only use the heated product by this time?
I doubt it. I doubt it because there were concerns that the heat-treated product was more expensive. And I've somewhere else in my statement, I've talked about the conversations I had in Newcastle.
Yes, and we'll look at the Newcastle situation in a few minutes. And then you say in the last part of paragraph 17.6 of your statement that in late 1984, the full implications of the AIDS virus were still not widely understood. It was widely understood by late 1984, wasn't it, that this was a virus with a high mortality rate and transmissible by factor concentrate. So what more information might the CSM have needed at that point in time?
I'm not sure. The full implications of the AIDS virus are still not widely understood. I don't know what I was saying there. I'm sorry. Now,
if we just then move forward from, this is late 1984, if we move forward to March 1986, MHRA 003634_002. So we can see the top of the page. This is a meeting of the CSM, 26th of March 1986, at which you were in attendance. And if we go to page 4, please, bottom of the page, you will see it says the safety of heat-treated factor 8 is the heading. And the context of the questions here, Sir Michael, is that Dr. Peter Jones, who obviously you knew, had raised concerns, as had others, about the Armour heat-treated product transmitting AIDS. And that's why the committee was looking at the safety of heat-treated factor 8. And it says the committee considered this paper and endorsed the recommendations of the subcommittee on biological products as follows. 1, the committee were glad to receive this data on the follow-up of alleged transmission of HTLV3 by heat-treated factor 8. The committee agreed that there was insufficient evidence for action to be taken on any specific product. I'll come back to that in a moment. If we just look at the top of the next page. 12.2, close surveillance should be maintained on the 2 possible cases of HTLV3 transmission in recipients of armour material. 3, the committee advised that if any of the data provided by manufacturers on viral inactivation suggested a danger, urgent consultation should be sought with appropriate members. Now, the first question, Sir Michael, is this. Where the committee's recommended close surveillance on the 2 possible cases of HTLV3 transmission. What kind of surveillance would the committee have had in mind? What would that have entailed?
Well, it would have asked the physicians the doctors looking after the patients to find out, to follow them up. There were 2 possible cases of transmission. Did they materialise or not? I think they'd want further details from the doctors looking after the patients.
Okay. So if we then just go back to the bottom of the previous page, if I can just remind you of the committee's wording there. So it refers to a paper, and then it says the committee agreed there was insufficient evidence for action to be taken on any specific product. Now, I just want to show you the paper in question and then ask you about that conclusion of insufficient evidence. The paper is at BPLL 0001351_018. And you'll see, Sir Michael, it's headed the safety of heat-treated factor 8.
Yes.
It refers in the introductory paragraph to Dr. Peter Jones making statements that he felt heat-treated factor 8 wasn't safe, citing in particular the armour product. I'm not going to take you through the detail of the paper now. I think we just need only go to the last page. And under the heading Summary. So you'll see this was by Dr. Rotblatt, who you mentioned a few minutes ago, 4th of March 1986. And she says this: there are 3 known cases of seroconversion for HTLV3 antibody after heat-treated factor 8. 1, the American case appears to have other risk factors. This case is associated with the Highland product. 2 cases seroconverted after treatment with armour material from a batch known to contain an AIDS donor. So you'll see from this paper, Sir Michael, there were 2 cases treated with armour. They've seroconverted. There were no other risk factors, and the batch was known to contain an AIDS donor. Why wasn't that sufficient evidence for the CSM to take decisive action about the armour product in March 1986?
I don't know. I just don't know, I'm afraid. Can't help you, sorry.
So I'm about to move to a different topic, so I don't know whether another 10-minute break would be useful.
Yes, that might be quite a good idea, a 10-minute refresher. So 25 to 3.
Thank you, sir. We're back in 10 minutes, Sir Michael.
Thank you.
Yes.
So, Michael, I wanted to ask you next, very briefly, about the prescription of drugs on a named patient basis, which you've addressed in section 18 of your witness statement. I don't think we need to look at your statement, but is this right? Doctors had clinical freedom to treat patients on a named patient basis with unlicensed products, and the CSM had no powers to intervene or regulate that situation.
That's correct. I think it was Section 6 of the Medicines Act. allowed doctors to prescribe under their own responsibility.
So would it be your view that there was effectively a lacuna in the regulatory scheme, with there being no regulatory oversight of the use of the named patient basis for prescription?
Slightly awkward to answer that, because I've got an example to give you, whereby I was a member of a committee a few years ago that advised the Surgeon General, and he wanted advice on whether it would be appropriate to give high doses of factor VIII to patients, people who'd have suffered catastrophic hemorrhage in Afghanistan, and he was going to, as it were, authorize it on a named patient basis. And this little committee I was on for the Ministry of Defence agreed that he should. And I'm sure it's, it was under careful control in that they'd had to have, at least 80 units of blood, but still were bleeding, and then they were given this factor VIII. This was years after, it was all quite clean and everything. And this happened at Camp Bastion, which was the hospital just about outside Afghanistan. And the amusing thing was that American physicians weren't allowed to do that sort of thing. So if they had a patient with catastrophic hemorrhage, they transferred them to the Brits, who could then give the factor VIII. So that was factor VIII being used on a named patient basis under rather exceptional circumstances, but it did sort of happen, yes.
If I can make my question clearer than I did, I'm not suggesting to you that there should be no means of prescribing on a named patient basis ever. The question really is whether you think, drawing on all your years involved in medical regulation, that there should be some form of regulatory oversight of that.
Well, I don't think so. No, I think you have to. I think it's reasonable to rely on the abilities of the prescriber.
Can I then move to Newcastle and your role within the Newcastle District Health Authority in 1984? BPLL 0002848_003, please, Paul. BPLL 0002848_003. You've got _001. Thank you. So we can see from the top of this, it's Newcastle District Health Authority report of an ad hoc group to consider the use of heat-treated factor VIII concentrate. And it says, at the request of the District Administrator and the Chair of the Hospital Medical Committee, we met on December the 4th, 1984, to consider the necessity and implications of using heated factor VIII concentrates in treating patients attending the Health Authority's Haemophilia Centre at the Royal Victoria Infirmary. And if we just go to the last page, first of all, bottom of the last page, we can see who the we are. It was you, Dr. Jones, and a number of others. Now, you're taking part in this in your capacity as chair of the Drug and Therapeutics Subcommittee. What was the role or remit of the Drug and Therapeutics Subcommittee in the Health Authority?
Well, it was to advise the Health Authority whether or not particular medicines could be used and how they should be used. Just for example, in the old days, pharmacists weren't allowed to undertake what was called therapeutic alternatives. So if a drug was prescribed under its brand name, the pharmacist had to dispense it. And so we recommended that shouldn't be the case, that pharmacists should dispense whatever was the least expensive products with the same product.
And if we go back to the first page of this document, we can see the background is set out in relation to the factor concentrates and transmission of infection, hepatitis and HIV. I just want to ask you about a couple of passages. First of all, bottom of the second page, please. So this is the last paragraph where you and your colleagues report 90 individuals are believed to have died from AIDS in the UK, including 2 heterosexual haemophiliac patients. Because of the known hematogenous transmission of AIDS, haemophiliacs are at clear and special risk of contracting the disease. Now, I just wanted to ask you about that understanding that haemophiliacs were at clear and special risk of contracting AIDS. That was clearly your view by December 1984. Can you remember at all when that became your understanding?
No, I can't remember. What was the date of that document?
This is December 1984.
So it'd be sometime during 1984, I guess.
Would it be your view, your professional view, that haemophiliacs themselves in the Newcastle region should have been told that they were at clear and special risk of contracting AIDS?
I think nowadays they should have been. In those days, we were a bit paternalistic about telling patients about problems, so it wasn't. So it was. Wasn't quite so common. But I think you know, in the modern context, yes.
Now, this ad hoc group is here looking at heat-treated concentrates, and you make recommendations on the last page where it says advice. You say our advice to the authority is as follows. And then you set out a series of advice, including the use of heat-treated concentrates. As far as you know, had your Drug and Therapeutic Subcommittee or the Health Authority itself had any previous involvement in discussing policies for the use of factor concentrates for haemophiliacs?
I'm afraid I can't remember. I'm sorry. No idea.
Do you have any general recollection of whether the Health Authority sought to exercise any degree of oversight or control over Dr. Jones and his prescribing practices, or was it very much left to his discretion as the director of the Haemophilia Reference Centre?
I think it was left to his discretion.
A completely different topic now, Sir Michael. DHSC 0105567. These are minutes of a CSM meeting attended by you on the 21st of November 1985. If we go to the second page, under paragraph 3, matters arising from the minutes. If we could zoom in on that section, please, Paul. So I just wanted to ask you this. This is about the CSM's decision-making processes more generally, Sir Michael. Professor Hull said he wanted it minuted that he had not been able to read and assimilate all the papers sent to him for the meeting. He thought that members were expected to undertake far too much reading for meetings. Other members expressed concern that whereas the open case showed them to be potentially liable for their advice, it was in practice impossible for them to be fully informed about all aspects of subjects on which they were asked to give advice. But just pausing there, do you recall it being a problem that you and your colleagues had too much to read and assimilate for these meetings?
Well, I used to spend, entire weekends reading the papers, but obviously Professor Hull found it more difficult, but I don't know whether this was a common complaint.
Okay.
Yes.
And then the second paragraph says, Dr. Carston suggested that business might be organised as for CRM so that all members were not asked to consider all papers. Professor Graham Smith said he did not think a subgroup approach would work satisfactorily. And then what I wanted to ask you about is your contribution. Professor Rawlins said that the committee had adopted a multidisciplinary approach to its work, with members taking each other's advice. He thought this approach provided a satisfactory basis for the committee's work. What was it you were referring to there as a multidisciplinary approach?
Well, the CSM, the Committee on Safety and Medicines, had a wide range of membership, including, as I already said, I think pharmacists and pathologists, special interest in toxicology. A pathologist with a special interest in toxicology. And we tended to take each other's advice.
So would that, in practice, mean that perhaps one member might, or one or two members might read the papers that related to areas within their expertise, others might read papers on a different topic, and then they would share information rather than everyone reading and assimilating everything? Was that the point?
Well, I don't think quite like that. No, I mean, I think there were probably some members, who are very specialist who only read things that are applied to them. But I think it was a real question of, if it was a sort of neurological topic in epilepsy or something like that, the members would take special note of the views of the neurologist. But I don't. But as far as I was concerned, I used to try and read everything.
Now then, without needing to look, I think, at any particular document for this next issue, can I ask you about the establishment of the Medicines Control Agency, which, as I understand it, took up the work of the Medicines Division in around 1989.
Something like that. Yes.
What difference did that make? Did the MCA operate in a different way from the Medicines Division?
Not really. The MCA wasn't part of the Department of Health, although it was responsible ultimately to ministers. But it wasn't part of the Department of Health, and so its staff weren't civil servants in the contemporary way. It also, actually, the Medicines Division too. It also, I think, at that time relocated to a building at the bottom end of south end of Vauxhall Bridge, called Market Towers, and there was just one guy in control.
And were there advantages to it not being part of the Department of Health, do you think?
I didn't spot them, to be honest with you, no.
The next area I want to ask you about is about VCJD. Now, you've dealt with and produced a number of documents exhibited to your statement. I only want to ask you to look at a couple of them and then just ask you a handful of questions about them. If we could go to WITN 6406033. So this is a document headed Action Taken Against the Theoretical Risk of Transmission of New Variant CJD by Blood and Blood Products. And it looks at a period from October 1997 to, I think, mid-1998. There are just two entries I want to draw your attention to. First of all, the entry, Sir Michael, for the 26th of February 1998. If we could just zoom in on that, please, Paul. Says, the Committee on Safety of Medicines recommends that UK source plasma should not be used for the manufacture of blood products because of the theoretical risk of transmission. And then if we look at the entry for the 13th of May, please, Paul, and just zoom in on that. CSM announced completion of their review of UK source blood products and recommend all such products should be replaced by non-UK source products once sufficient stocks of non-UK source are available. And then over the page, there's the heading leukodepletion. I don't need to read that. And then the words theoretical risk. It should be emphasised that the transmission of new variant CJD by blood and blood products remains theoretical, and all the actions that have been taken are precautionary to guard against the possibility of such transmission. Now, it might be said that that's a very different approach being taken by the CSM, and indeed others, in the late 1990s in relation to new variant CJD, not looking for clear or conclusive or sufficient evidence of transmission, but taking a precautionary approach to guard against a theoretical risk. Well,
Yes.
Is it right to understand that it was a different approach? And what, if anything, can you recall about that?
Well, ultimately, it was really based on a judgment. The CJD, new variant CJD, appeared in the early 1990s, and it seemed to have been, it happened when we started feeding cattle with sheep offal. Sheep had CJD for hundreds of years in the form of, it was called scrapie, because it irritated the skin. And the question arose was, if scrapie could get into cattle, could it go from cattle to human beings? And it was, but some people suggested there was a species barrier, and that it wouldn't get to humans. But it was really a suggestion, and so there were some things we could do quite easily, and that was make sure that catgut wasn't used, and other forms of it. The real problem, and I go into it in my witness statement somewhere, the real problem was that vaccines were prepared using fetal bovine serum, and we weren't self-sufficient in that. And so what we did was, we recommended, well, there were two possibilities. One was that we could abandon all immunization, which would mean that the emergence of mumps, measles, rubella, and all that sort of stuff. Or alternatively, we should source the material from New Zealand. But that would take 3 years to come on stream. So eventually we recommended that it seemed unlikely that there was some sort of species barrier, and therefore we recommended that we should continue to use fetal plasma from British cattle in order to sustain the immunization program. We were right, but for the wrong reason, because it turned out that CJD isn't transmitted from cows to their calves. So we got it right. We did the right thing, but for the wrong reason.
There were obviously a series of decisions that had to be taken by the CSM in the course of the 1990s. But if we look specifically at the CSM's review of blood products in 1998, at BART 0002128_004, so this is a press release, May 1998, and we can see in the third paragraph explains that the CSM has reviewed blood products, advised that manufactured blood products should not be sourced from UK plasma for the present time, and then there's a quote attributed to you, and then it says the reasons for moving to non-UK source plasma for the time being are that although there is currently no evidence that NVCJD can be transmitted by blood, there is necessarily a theoretical risk. And then if we just look at the last paragraph, there's a quote from you. Professor Michael Rawlins said, no new evidence has been reported indicating that the new variant CJD can be transmitted via blood products. However, while the risk remains only hypothetical, it cannot be fully discounted. And then you go on over the page to set out various measures that will be taken. So it would seem that the CSM was taking what might be regarded as a radically different approach in the late 1990s, this precautionary approach, taking measures notwithstanding the risk being only hypothetical or theoretical. Do you recall whether the CSM understood that or believed that what it was doing was something different from how it had approached matters in the 1980s?
I don't think so, no. I think we were just acting what we regarded as reasonable. What's happened here? Can you hear me?
Yes, we can hear you.
Because it's suddenly gone. Oh, it's back again. As I said, the real problem was the whole question of sourcing fetal serum albumin in order to make vaccines. And eventually, we decided that the risk of having outbreaks of measles, MMR and so on, outweighed the potential, the theoretical risks of transmission of CJD.
Can I then just ask you a little about NICE and then the MHRA? In relation to NICE, you were the first chair, you've told us, and NICE's role was essentially to improve outcomes for people using the NHS by producing evidence-based guidance and advice for health and public health practitioners. Was there any body performing that role prior to the establishment of NICE?
No. Well, yes and no. When NICE was set up, it was asked to look at two things. One was to look at the clinical and cost effectiveness of new and existing medicines, and secondly, it was asked to develop guidelines, evidence-based guidelines. Guidelines had been around for many years, but they were all rather mishmash. They were done by royal colleges, and they weren't done as an evidence-based. They were often groups of chaps having a coffee in one evening or a drink one evening and knocking up a guideline. So we were expected to produce responsible guidelines. The question of cost effectiveness was actually quite interesting, because when I was chairman of the CSM in early 1998, I was summoned to meet Baroness J, who was a minister, who asked me whether the Committee on Safety Medicines, having made a decision about whether a product should go on the market, would then make a second decision about cost effectiveness. And I had no idea this is what question you were going to ask. So I said, no, I wouldn't advise it. I said, I know committee behaviours. If the Committee on Safety and Medicines knew that in 15, 20, 30 minutes' time it had got to make a rotten decision on cost effectiveness, it would fudge the first one. You'd always find something wrong with quality, safety and efficacy. So it would fudge the first decision. So I said they should be made by a separate organisation. And at that stage, I hadn't thought about NICE, but anyway, I think as a result of that, NICE did the job.
And then, in terms of the MHRA, which you chaired for a number of years after you had been at NICE, what were the principal differences, if any, between the system of regulation under the MHRA, as you saw it in, I think, 2015 onwards, and the CSM and the licensing authority work which you previously had experience of in the 80s and 90s?
Well, by the time when I joined the MHRA, we were still in the EU, and licensing decisions are primarily made by it was actually the Commission, but by the CPMP, the Committee on Proprietary and Medicinal Products, which advised the which advised the EMA. And the detailed assessments were carried out by two member states' regulatory authorities. One, they were called rapporteur and co-rapporteur, who looked in detail. And so, but now at the MHRA, and it was before we left actually formally left the EU, we were having, as it were, to accept decisions of the CPMP, the EMA, and ultimately the Commission. We had at least one member of the staff was a member of the CPMP, but it was a rather different sort of regulatory system. We didn't really give out product licenses on our own responsibility.
And then one final general question for now, Sir Michael. Looking back, drawing on your years of experience both at the CSM and in healthcare regulation at NICE and the MHRA, and having regard to all the materials that you've been provided with for the purposes of making your statement, do you think that the CSM failed adequately to recognise and respond to the viral risks posed by pooled plasma products in the late 70s and 1980s?
Well, obviously, in a sense, yes. I mean, they weren't recognised, and in many ways it was understandable because, you know, that hepatitis had hardly been heard of and AIDS didn't appear until in the 1980s. But I feel desperately sorry because the CSM and the licensing authority inadvertently harmed hundreds and hundreds, if not thousands of people. And I'm very sorry that we did that. It wasn't deliberate. At the time, we were trying to do the best we could for patients. But in retrospect, it wasn't good enough.
So those are the questions I'm proposing to ask Sir Michael, but we would now need to take a break to enable core participants and legal representatives to suggest any further questions. So could we take 30 minutes, please, sir?
Yes. Let me just explain to Sir Michael. Sir Michael, what we do now is give a slightly longer break. There will be some more questions after that break, but during the break, the legal representatives of core participants will be suggesting to Council what further questions they would like to be asked, because an inquiry is a participative enterprise in which all the core participants have a part to play through their legal representatives in ensuring that we get the best from every witness. That's what's going to happen. And I can't say it will be half an hour exactly, because we have to give council time. There may be more questions than half an hour for her to field. So we'll say not earlier than 20 to 4. It may be a little bit later, but you'll be told. But it won't be before 20 to 4. So you've got to break at least till then for a cup of tea or whatever. And we'll meet again then. I can't say how long it'll be after that. It depends how many questions there are. But it's the last leg of your evidence for the day. So 20 to 4.
Thank you, sir.
Thank you.